Welcome. Today, I'll be speaking about the major facts and holdings of the case of Silberberg versus Builders Collective of Australia Incorporated. The applicant in this case was Mr. Ron Silberberg. He is of Jewish race and ethnicity. He was the Managing Director of the Housing Industry Association, or the HIA. The first respondent in this case was the Builders Collective of Australia. The collective conducted a site which includes a forum relating to the building industry. The emphasis in the forum was placed on debates about warranty insurance, and only registered users can post on the forum, both Australian or overseas users. The terms and conditions of the membership authorised the collective to remove data that violated their policies, and the user had to agree to not post hate speech and other harassing messages. Messages were posted automatically without intervention by the collective. Postings were reviewed occasionally, and the president, including other people, were responsible for reviewing those messages. The policy of the collective was to delete objectionable material once made aware. All of these facts are related to the case against the first respondent, which is the failure to remove offensive material. The second respondent, Mr. Ken Buckley, was a registered user in the forum and wrote racial messages towards Silberberg because of his Jewish ethnicity. It was implied that because he was Jewish, he had an excessive monetary focus within the HIA, and that he had exercised control over the building industry as a means of making money for himself and his rich friends at the expense of the membership of the HIA. These messages were deleted by the collective several months later by reason of a letter sent by Silberberg's solicitor. It was found that 1 month prior to the removal of the messages, an admin had responded to one of them in affirmation of the content inside it. Justice Giles was satisfied that the response by the admin was sufficient to indicate that the admin read the message and that any reader would likely pick up on the racial imputation inside of it. The relevant legislation in this case was Section 18C, Section 3 subsection 3 and Section 18B of the Racial Discrimination Act 1975. The case against Buckley was simple. The messages weren't after publication, following the case of Jones v. Tobin, that they were reasonably likely to offend, insult, humiliate or intimidate Silberberg or other Jewish people, and that the reason for publishing the messages was explicitly because of Silberberg's Jewish ethnicity. The case against the collective was a bit more complex. The question that the court had to answer was whether the collective breached the RDA because they published/allowed the messages to be published on the forum. Justice Giles referred to a number of cases involving a number of intermediaries which would be held liable in cases of publications of defamatory material, and in this case he held that in a defamation case the collective would be held responsible, even if it was only an agent who knew of the offensive messages, because they chose to conduct an open and anonymous forum available to the world without any system for scrutinising what was posted. His Honour said that a party in a controlling position of a website of such a nature is not different to publishers of other mediums. His Honour then went on to state that the failure to remove the offensive material within a reasonable time was an act caught by Section 18C of the RDA, but no connection could be made out between the failure to remove the material and Silberberg's race/ethnicity because it was a lack of diligence rather than racial vilification that was the reason behind the failure. Accordingly, the case against the collective was dismissed, but the case against Buckley was successful. Thank you.